Okay, so let's do a little training on the new California purchase agreement. This is the one that came out in December of 2021. Don't want to make it complicated. I just want to start off by saying, the purchase agreement, in my opinion, really needs to be like your best friend in the real estate transaction, because everything about the real estate transaction is written in the purchase agreement. So, any disputes or disagreements or miscommunications with agents on the other side, the answers can be found in the purchase agreement. So real quick, the first page, just like before, you're going to be making an offer from a party here on a property located with the parcel number, right? And then you're going to have your agency disclosure. Who's the selling broker's firm is, who's the buyer's brokerage firm is. That information goes in here. And then the biggest difference is going to be what is called the grid now. And everything in the grid, and the grid is going to be on pages 1, 2, and 3. Everything in the grid is located in paragraph number 3. So you can see the 3 here. This is 3A, B, C, D, D1, D2, E1, E2, E3. So as you go down through the grid, everything is in paragraph 3, and as you're reading the body of the text throughout the RPA, it will refer back to, when it refers back to the grid, it will refer back to paragraph 3 something rather. Also, the second column in the grid is kind of like a reverse reference. If you want to know more information about the initial deposit, you'll find it in paragraph 5A1. If you want to know more information about occupancy type, you'll find it in paragraph 7A. So it makes it really easy for you to go find out where in the RPA the language is that supports this term or this part of the contract. So just as with before, real simple to fill out. Essentially what they're doing now is taking everything that we've known in our old purchase agreement and they're pulling it up to the first 3 pages and putting it in the grid, making it really easy to find, really easy to reference. If anybody's ever done the summary of multiple offers page, it's kind of set up like that as well, where the key points of each offer are side by side. This is kind of the same way they pulled it up, same format. Purchase price, whether it's all cash, close of escrow, so you can go days after acceptance or specific date. Expiration of offer, instead of being on the last signature page, is up front now. It defaults as 3 calendar days, or you can choose a date, and it defaults at 5 p.m. unless you want to choose a different time. Your EMD, your earnest money deposit, or initial deposit amount, will go here. When you put that dollar amount in here, it will auto-populate a percentage of the purchase price. If you have a listing agent that wants you to use 1% or 2%, and you put the number in, it will tell you what your percentage of your EMD to the purchase price is. Defaults with 3 business days to get that in, and it also defaults as a wire transfer. So if you want to do it as a personal check, you're going to need to write it in there. We usually do not do increased deposits unless you're doing an increased deposit, you would probably skip over this section, but if you were, you would put that in here as well, and then whether you're going to be removing contingencies at that time. Loan amount, your first goes here, and again, it's going to put a percentage of the purchase price, so it actually puts your LTV, right, your loan to value in here. So if you have a $500,000 purchase price and you're doing a conventional 20% down and you put $400,000 as the loan amount, this number should be 80%. Or if you're trying to calculate an FHA and you put the purchase price and you have your loan amount, right, which is 3.5% down on FHA, so your loan amount is 100 minus 3.5, which is 96.5. This number should be 96.5%. Otherwise, you've made a calculation error, and you need to fix that. The loans will default as conventional unless you check your FHA, your VA. I wanted to just highlight this section here. We've had some issues with people writing offers, and they're checking the all cash box. but they really have a private lender or a hard money loan. So it's not technically cash because there still has to be some kind of approval process to get that money. It's not their money. It was not in their a savings account or their checking account. So that's where you would hit this other, put in private lender, hard money, or if you're using a different loan type that's not listed here, you would use other there as well. Additional financed amount, again, you're probably not doing that very often where you have two loans, right? So back in the day, there was a lot of 80-20-0 loans. Those were people that were going out and getting a first at 80% loan to value, a second at 20% loan to value, and then they were using zero of their own money down. That was some of the creative financing when you were doing like zero equity type purchases. Then your occupancy type, primary, secondary, investment. And then what's really cool is if you've done everything correctly, your purchase price, your EMD, in your loan, it will pull up the balance of your down payment because it has a formula in here, and your purchase price total should equal each other top and bottom here. Okay, so that's page 1 of the RPA. Okay, so moving on to page 2. This is now an area where you can put a seller credit to the buyer. So you would put the amount of seller credit that you'd want to ask for in the contract here, and it is defaults to be applied to closing costs. Again, it's really cool because when you put the amount in here, it will populate a percentage. So it's a little different than when we used to write them before, where you would say seller to contribute up to 3% of the purchase price. You actually have to put the dollar amount in there now, and it will calculate it, so you'll know if you hit that 3% number or not here. So that's that section. Additional finance terms, that's an area where I would maybe use like escalation clauses, or possibly the buyer committing a certain amount towards a short appraisal gap coverage. I would put that in that section right there. Then our verification of cash, if it's an all cash purchase, or if you need to show them the verification that you have the money for the down payment and the closing costs, 3 days default. And then here, the loan application, you also have 3 days to let them know that you've gone out and filled out an application for a loan, unless you want to already attach a pre-qual, a pre-approval, or a fully underwritten pre-approval, then you would check these boxes over here. Moving on to final verification, right? That's going to be your VP. 5 days prior to close escrow, you're going back in to check for repairs and making sure the house is still in the same condition it was at the time of the acceptance of the offer. And then a new one here that's caused a lot of confusion, this assignment request, 17 days after acceptance. And we'll talk about the assignment request as we get to that in greater detail. Then all of your big contingencies are pulled up all up to the grid here in one spot, so they're really easy to find. Your loan is at 17 days. Your appraisal is at 17 days. So the loan used to be 21, so that got a little faster. Your investigation of your property, 17 days. The review of the seller docs, 17 days. Preliminary title report is up front here now, easy to see, 17 days. Common interest disclosures. So those are going to be your HOA type docs, right? Anywhere where there's a common interest, so like amenities and homeowners associations, right there. Review of leased or liened items is here, and then also the COP, the sale of the buyer's property contingency, exists right here as well. You just check the box, and it'll auto-populate the COP form. Over here on the right side, if you want to remove the loan or appraisal going into the offer, you would check those boxes here. A little reminder that if you have a loan type that requires the FVAC, so those are going to be your FHA and VAs, that removing the appraisal contingency here does not eliminate the appraisal cancellation rights that are written within the FVAC. So just be aware. Also, letting you know that you can remove any of these contingencies by using a CR attached, but it also does give us a nice little language here that says if you remove or waive any of these at the time the offer is made, you're doing so against the advice of the agent. Okay, so that's also really, really key. A little further down on page 2, and we'll talk about this a little more as we get into this a little further, but time of possession. Wait for the train. There we go, gotta love Tehachapi. So time of possession is at the time of notice of recordation, right? So that's when we get notified by Escrow that it has closed, that they've stamped it down at the recorder's office, right, that it's recorded. So now possession changes when we get notification, unless you want to make it at 6 p.m. or pick any time or pick any date specified, which would be applicable in paragraph 3M2, which is the next one down, which is the seller occupied, where you're going to attach a form SIP, seller in possession, and you're going to make the change of possession based on a date later than the close of escrow. Okay, so we'll talk about this, and that's why I have it highlighted. We're going to talk about it more later on. Really important things to talk about when it comes to the differences in the transfer of possession and the change of ownership. Okay, if you have tenant-occupied units, then it talks about the tenant-occupied property addendum. That would be here, and then moving further down, we're just going to start talking about some of the things that the seller has to do. These are the seller timelines: delivery of documents, reports, disclosures, material facts, 7 days. Signing and returning the escrow holders' provisions and instructions for both sides, 5 days after receipt of them. And then time to pay fees for ordering HOA docs. So the seller's got to get the fees over to the HOA company 3 days after acceptance to get that process started. This one's we'll talk about later as well. Install smoke alarms, CO detectors, and the water heater bracing. The seller has 7 days to get it ready to go, and this is to help make sure the house is ready for the appraiser, and we're not having to deal with re-inspections on that. And then evidence of representative authority. Again, this is kind of like the old RCSD. The RCSD is kind of becoming obsolete now, as we will show later on when we get to the signature pages. The RCSD is now built into the RPA, but you would have to show 3 days after acceptance what your role is, if you're the trustee of a trust or the managing member of an LLC or the owner, CEO of a corporation, or if you have power of attorney or any of the other RCSD representative capacity situations. So that's the end of page 2. Now moving on to page 3. So before, when we talked about what would be included with the home, it was basically just refrigerators, washer, dryers, right, and stoves. Now it's grown a lot more as the argument over what items are actually attached as fixtures to the home, as that debate has waged on, and we're getting some more clarification with technology. We have things like video doorbells and security systems and security cameras and smart home control devices. So those things to mark. It used to be, if you guys remember, a flat screen TV that was mounted to the wall like this one. The TV was personal property, but the mount, because it was attached to the house, was considered a fixture. Now you actually have to check the box if you want the brackets or the wall mounts, okay? Because now those can be removed and taken like personal property. So we have dishwashers, microwaves, wine refrigerators are in there now. So take a look at this section. These are all the things that you want to add into the contract for personal property type things. You would add additional items here if you wanted to add more things, and then exclude would be here just like before. So just be aware of the different items that are up here. The next section, which is section Q, so we're still in paragraph 3, but now we're in paragraph 3Q, and this is the allocation of costs. So this is how we determine who's going to pay for what, and whether or not we're going to ask for those certain reports to be done by any specific providers or any particular companies. So your NHD, right, is up here at the top. Pretty simple. If you want the environmental, you check the box here. You can put your provided by company right over here. This is where we probably do your pest report, maybe your roof inspection, maybe a sewer line camera scope, or your septic, and who's going to pay, and maybe who's going to do that report if you don't want it to be seller's choice. Smoke alarms, CO detectors, water heater bracing, you can choose for the seller or the buyer to pay, or both, or however you want to do it. If you have any point of sale corrective things, say you have a house that's in a city where the city's going to come and check to see if their compliance is up to date, if there's a compliance report against the house, and they're going to stop the sale of the house until that the house is back into compliance, you can put who's going to pay for that, seller, buyer, however you want to do it. Escrow fees, owner's title insurance policy, you get to pick the escrow holder, and you put the title company in here only if the title company is different than the escrow holder. One thing we've seen so far is people that are putting in the big long escrow company's name and then the escrow officer's name. Because it's too big for this space, it's creating a text overflow addendum, so just be aware of that. It creates an extra page where it just has just that information in there. Let's see, buyer's lender title insurance policy, it defaults as the buyer. You would have to agree otherwise if the buyer wasn't going to pay for it, but pretty standard. Most transactions, the buyer pays the buyer's lender title insurance policy. County, city transfer taxes, HOA, prep fees, seller default there, HOA transfer fees, private transfer fees, and then if you want to put in some other ones here, if you need more space, there they are for fees or costs there. And then your home warranty plan, you put your cost over here, who's going to pay for it, and you can pick your company over here. This line spacing here is the type of home warranty plan. Maybe you want to make sure it's like an upgraded plan or something of that sort. Other terms, if you need space, there you go. That is page 3. Moving on to page 4 now, we have all of your addenda, and those are all going to be up in this section here. One thing that CAR wanted to do was to create one purchase agreement. So now when you're doing a manufactured home, instead of doing that on a separate purchase agreement, you're still using this form, but now you're checking this box for the manufactured home purchase addendum, and it will pop it out. It'll populate it, and you can fill that out. So everything is kind of done that way now. Probate, purchase agreement addendum is here, and then these addendum here for your short sale, your court confirmation. Addendum is here. If you're doing a SWIPy, septic well property monument and propane addendum here. Remember, this houses that are on propane, you should have one of these so that you can figure out your propane issues and not fight about them as you're closing escrow, which seems to happen quite a lot. If you're in backup position, there's your backup offer addendum, or any other addendum that you want to add it here. If you're writing an offer and you want to add something like that, you need to make sure that your addendum is attached to your RPA. You have to make sure that anything that you want as a condition of your offer is attached to the offer. Otherwise, technically, they could respond to the offer and not to the addendum, if that makes sense. So make sure you attach it here by checking the box and putting the number in. Also, if you have a 1031 situation, intent to exchange for both buyer and or for the seller. So those are your intent to exchange forms there. Advisories, like we've always had in the past. Of course, we're all familiar with the statewide buyer and sellers. There it is there. If you're on a short sale, trust advisory, REO, probate advisory. These other ones are already pre-checked because those are the ones that precede the between the agency disclosure and the actual purchase contract. So those are these 4 here, or sorry, the 2 of them, the wire fraud, right, and the fair housing one, and then the California Consumer Privacy Act and the buyer inspection advisory, of course, are after the RPA, but still attached. Okay. If the wildfire disaster advisor, please take a look at that one and read that one. We see that come across a lot in offers because the agent believes that because it's in a high fire area that they need to put that advisory there, but reviewing that advisory, you'll find that's for homes that exist in an area that was just ravaged by wildfire, and it talks about the toxicity that might be in the soil from things burning or from things falling out of airplanes, right? Phos-check, fire retardant, things like that. So it talks about the possibility for pollution in the area because it was in a wildfire zone. So read that one and get to know it. Okay, moving on, we start talking about the bones of the offer. This is all the language. So we're talking about our initial deposit, increased deposit, retention of deposit, cash offers, loan, your first loan, additional finance loan. So, stuff that we've all seen before. There are some items that, as we go through this, I've already highlighted to kind of talk about. So the first one, I'm not going to talk about every single one of them. It's something that I probably read and went, oh, this looks pretty cool, we should talk about it. We'll talk about limits on the credits to the buyer. If you remember earlier up in the contract, we showed you where you could write the seller credit. And so what this lets you know is that if the seller credit amount that's on the contract, so the contractual amount is higher than what the lender can actually use, then the contractual amount on the contract will come down to the amount that the lender can use, right? So on the contract it's here, but the lender can only use this much. This will drop down contractually, and there will be no automatic adjustments to the purchase price to make up the difference between the contractual credit and the lender allowable credit. So be aware of that here. Nice to know, no arguments over credits. And so that's pretty much it for page 4 of the RPA. So moving on to page 5, a lot more to talk about here. Condition of the property on closing. So if anybody who's been around me knows how much I used to love paragraph 11 on the old purchase contract. This is essentially my new paragraph 11. So now 7B1. 7B1 is going to be my favorite paragraph. Unless otherwise agreed, the property shall be delivered as is in its present physical condition as of the date of acceptance. So what does that as is mean? Okay, so you got a buyer that comes to you and says, hey, I sold my house down in San Diego and I had to pay for everything to get it closed. They made me, they gave me this big report and I had to fix everything. So don't these people up here have to fix all of their stuff before I buy their house? The answer is no. The house is being sold as is. When people write on a contract, we're going to give you $500,000 cash, 21-day escrow as is. It's like, yeah, no joke. It's always as is. Every house is sold as is, unless you otherwise agree. And there are a couple of different ways to otherwise agree. Otherwise agreed can be how you write your offer. So if you're putting on your offer, you have a pest report and you want the seller to pay for section 1 clearance of any termite or dry rot findings, then you've agreed that the house is being sold as is and with those fixes, right? So that's how you write stuff in to kind of override that as is a little bit. Also, when you're done with all your investigations, you can create a request for repairs, form RR. And if they agree to them, then it is otherwise agreed. So it's as is, except for what you agree on, right? So the house is delivered in as is condition. There you go. As of the date of acceptance, whatever condition the house was in at that time. Okay, that's sentence 1. Sentence 2, the property, including pool, spa, landscaping, and grounds, is to be maintained in substantially the same condition as on the date of acceptance. Substantially, not exactly, but substantially, not kind of, substantially. Whatever that means, right? That's up for debate, but it means it should be pretty much the same, substantially the same, sorry, I kind of contradicted myself there, as it was when you accepted the offer. So the pool, if it was blue and clear, must be blue and clear when you take over ownership or possession, of the house. It can't be green, it can't have frogs living in it and tadpoles and stuff. The spa, same thing, right? It's got to be in same condition. If it was usable then, it's got to be usable now. Landscaping and grounds, you got to keep watering your plants, keep watering your grass. Trees can't die, grass can't die. So also the condition, other things maintained, like if the door to the bathroom didn't have a hole in it, it shouldn't have a hole in it now. Same with the walls. They shouldn't be changing doorknobs. They shouldn't be changing fixtures, right? You had really nice, brass fixtures in the bathroom, and now you come in and they're cheap, low-grade brushed nickel or something like that. So same condition as of the date of acceptance. Okay, sentence number 3. All debris and personal property not included in the sale shall be removed by the close of escrow or at the time possession is delivered to the buyer, if not at the same date. Okay, so a couple of things here. First, debris and personal property not included with the sale shall be removed. So, debris is just like rubbish, trash, junk, stuff out. Personal property, furniture, barbecues, things like that all need to be removed. Debris can be things like, say you jackhammered out a patio and there's a pile of concrete in the backyard. That needs to be removed. You pulled down an old chain link fence and rolled it up in the corner of the backyard. That needs to be removed. Okay, now it says either by the close of escrow or at the time possession is delivered to the buyer. So what is the difference between those two? Well, the close of escrow is the time at which ownership transfers from one party to another. The delivery of possession is when you actually take possession of that property. How can those two things be different? Well, as we saw earlier, you're going to get the, so you can have it where they happen at the exact same time. So at the time of recordation, unless it's otherwise written that you're going to do it differently, when the county stamps that deed and everything transfers, you get possession and ownership at the same time. Now, what about if you have them until 6 o'clock in the evening that day, but you record at 11 o'clock in the morning, right? Well, then your ownership transfers at 11 o'clock in the morning, but your possession doesn't transfer until 6 p.m. Or if you have a seller in possession for a day or 3 days or a week or 2 weeks, right? Anything 29 days or less, then you have change of ownership at the time escrow closes, but transfer of possession up to those 29 days afterwards. So that's really important to remember. They're two different things. And people will get that confused. They'll say, hey, I own the house. I should be able to go over there and, go in, take a look around, move my stuff in. No, the people are still there if you've given them permission to be there. So you don't have possession quite yet. Okay. Here's where it gets even more fun. If items are not removed when possession is delivered to the buyer, not ownership, not the close of escrow, but possession, if those items are not removed, the item shall be deemed abandoned. We'll come back to this. It's really important. The buyer, after first delivering to seller written notice to remove the items within 3 days, may pay to have such items removed or disposed of, and may bring legal action as per this agreement to receive reasonable costs from the seller. So, the items that weren't removed by the time possession is delivered are abandoned. Now, what happens if the new buyer coming in wants those items? Does he have to give written notice? No, he does not. They are deemed abandoned at the time the buyer takes possession. They are his. So if he wants them, they're his. That's it, plain and simple. If he doesn't want them, then, and he wants them off the property, then he has to give a 3-day written notice to allow the seller to come back and get them. If the seller doesn't come back and get them within the 3 days, then he can move forward with the process of having somebody remove them for him and get him out of there, and then go back and try to recoup his money from the seller, with a legal action of some sort. So, a lot to unpack in that little paragraph right there. Okay, other spot where there's some great language to help protect us. The buyer is strongly advised to conduct investigations of the entire property in order to determine its present condition. Sellers and agents may not be aware of all defects affecting the property or other factors that the buyer considers important. Property improvements may not be built according to code, in compliance with current law, or have had all the required permits issued and or finalized. Big sentence right there. I like that one. Protects us a little bit, right? It kind of lets the buyer know that the buyer still has the responsibility to take care of that stuff. Okay, so here we go with more of the difference in possession versus close of escrow. If there is a seller in possession SIP form signed, then the parties are advised. I like this part again, right? Because they always ask you, well, what's my legal? What does that mean? What rights do I have? And we should not be trying to tell our clients, either buyers or sellers, what their rights are in an SIP, because we aren't the insurance companies, we aren't the loan people, we're not the mortgage folks, we're not attorneys, so we shouldn't be giving advice. So it clearly states right here, the parties are advised to consult with their insurance and their legal advisors for information about liability and damage or injury to persons and all personal and real property. Buyers advised to consult with the buyer's lender about the impact of the seller's occupancy on the buyer's loan. What does that mean? Well, like a lot of lenders will say, you have to be moving the house within a certain period of time, or they're going to start looking at it as an investment property, and that wasn't the kind of loan you got, right? You got one for a primary residence. That's even bigger with like FHA. So you'll see there's reasons why the SIP is 29 days or less. Because once you go to 30 days or more, it's no longer a seller in possession. Now you have a tenant, and you have a tenant-landlord relationship, and there's tenant laws and tenant rules and things that totally change. So you never want your SIP to be for more than 29 days unless you're planning on going into a lease situation. Okay, so that's what this is talking about here. So that's how it can affect the buyer's loan. And also to consult with the qualified California real estate attorney where the property is located to determine the ongoing rights and responsibilities for both buyer and seller with regard to each other, including possible tenant rights and what type of written agreement to use to document the relationship between parties. Okay, so that's what we're talking about right there. Right? That's really super high level stuff that you don't want to get into as an agent. Okay, so another one. Seller shall, on the close of escrow, unless otherwise agreed, and even if the seller remains in possession, really key right there, provide keys, passwords, codes, and means to operate all the locks, mailboxes, security systems, alarms, home automation systems, internet connected devices, included in the purchase price, garage door openers, and all items included in the preceding paragraphs, and so on and so forth. Access to the homeowners association amenities, facilities, so on and so forth. So even if the seller is staying in possession, they still must deliver all these things, even though that does not give the new buyer the right to enter the home, right, with the seller still in possession, but they still have to be able to have all the items that belong to them now. So like, a garage door opener or house keys, copies of house keys and things, security systems and alarm codes and so on and so forth have to be delivered to the buyer. Now, if you read the SIP, the seller in possession, it's very clear about when a buyer can come into the home and the seller is still in possession of. First, if there were any repairs that the two sides agreed needed to be done, then the new buyer can come in with the contractor to get those repairs fixed. If the new buyer has talked to the old seller and says, hey, look, I want to bring somebody in to measure for blinds. Can we set an appointment? Yeah, sure, no problem. You can come on in, measure for blinds. If there's an emergency, you can enter the home. It's got to be an emergency, though. But you can't just come by and come in the house and be like, oh, it's my house. I thought I'd sit on your couch and watch TV and wait for you to get home. You can't do that kind of stuff. Okay, so with that said, for the most part, let's see. I don't know if I wanted to talk about this one or not. Oh, yeah, we'll talk about this a little bit too, and they'll be into page 5. On the appraisal, it's really important to note and to have these conversations with your buyer. If you're writing offers with no appraisal contingency, which we're seeing a lot of in this competitive market, so if you mark that box, then the buyer may not use the loan contingency to cancel this agreement if the sole reason for not obtaining the loan is that the appraisal that's relied upon by the buyer's lender values the property at amount less than specified in paragraph 3L2. If the buyer is unable to obtain the loan specified solely for this reason, the seller may be entitled to the buyer's deposit. So basically it's saying you can't just write an offer with no appraisal contingency hoping to get out of it because the lender won't be able to satisfy the loan on the appraisal. If you could still qualify for the loan, but now you just don't have the money to cover it, and you went in with no appraisal contingency, your buyer could be losing his EMD. If that makes sense. All right. So again, have these conversations with your buyers before you're writing these wild offers. And that is the end of page 5. Okay, moving over to page 6. The one I just wanted to talk about was just right here in this area where we talk about the removal of contingencies with your offer, right? When you're waiving them, when you're writing the offer. And we read a little earlier in here that it's against the advice of the agent, right? So let's kind of jump into that a little more. The buyer shall have no obligation to remove a contractual contingency unless the seller has provided all required documents, reports, disclosures, and information pertaining to that contingency. So that's like basic in the contract, right? We have they have 7 days to provide us with those reports. We have to review those reports, and as we approach that contingency, if there's some reports that haven't been delivered yet, we can send them a notice to perform, reminding them that they need to get us some stuff. If they send us stuff late, we have 5 days to review those things, right? We don't want to get rid of those contingencies until we've reviewed everything and we feel comfortable moving forward. But what happens if a buyer does remove a contingency when they're writing the offer? So it says here, if the buyer does remove it without first receiving all the required information from the seller, then the buyer is relinquishing any contractual rights that apply to that contingency. So if you write an offer with your inspection contingency waived, you don't have any rights. If the house is junk, right? You can't say, oh, I'm getting out because of the condition of the home. No, you already removed them. So if a buyer removes or waives any contingency without an adequate understanding of the property's condition or the buyer's ability to purchase, right? That's loan contingencies. Buyer is acting against the advice of the agent. So don't do it if you really don't have to. I know that there's a lot of really competitive stuff out there, but come up with other creative ways. Or make sure that you're talking to your client very clearly about what they could be giving up, okay? So that's, and then here's a little more on removal. We'll just talk about this section real quick and we'll move on. But if a buyer does not remove a contingency within the specified time, the seller, after first giving the buyer a notice to perform, shall have the right to cancel this agreement. So how does this work? So you're coming up on the end of your 17 days of your inspection contingency, and if you haven't removed it yet, it just will continue in perpetuity. It just moves forward, that contingency. And even though it's appropriate for the buyer to remove it if they've gotten all the information gathered and moved forward, the way that it works in California, it's contingencies are actively removed. They're not passively removed, meaning that when the 17 days comes and goes, the contingency doesn't evaporate and passively remove itself. It has to be actively removed by that person, typically, who has to enforce the contract, which is going to be the seller. So the seller sends the contingency removal form, right, over to the buyer to remove the contingencies. And if they want to enforce it, they enforce it with the notice to the buyer to perform, which gives the buyer 48 hours to get rid of that contingency. If they don't remove it within the 48 hours, then it puts the seller in the position to be able to cancel the contract because the buyer is now in breach of contract. Now, that does not mean that the EMD automatically goes to the seller. If the contingency was still in place at the time that the contract is canceled, then the buyer has a contingency in place and thus can get his money back. So we can talk a little bit, we'll talk a little bit more about that as we get deeper into this, but that's just kind of briefly touching on that for now. And that, for this point, is all we really need to talk about here on page 6. The rest of this was leased and liened items down here, and then items included in the sale. We talked about a lot of that already up above in that big grid, and we had the reviewing of the leased or liened items and condominium plan unit development disclosures and title, a preliminary title and title insurance and such. The preliminary title report was all in this area. So page 6, not much to talk about.